In addition to sending a message to any group that elects to assemble in order to intimidate others.
Senator, I think that we all agree with many of your sentiments and motivations. I do, and I hope the ACLU is here, but I do wonder about the constitutionality of this and whether this implicates the right to free assembly. And Claire, around?
Intent to intimidate. Who wrote this?
Yes, Mr. Chairman.
Does the ACLU have any concerns about the implications of this on any component of the Bill of Rights?
Mr. Chairman, obviously, the Bill of Rights and the First Amendment guarantee the right to assemble peaceably. And I think there are some pretty serious enforcement issues around proving this intent. We have not taken a position on this bill. We have stated that we can't support other legislation that's been introduced. I think it's important for the committee to be aware that every single Virginian between the ages of 18 and 55 is by statute a member of the unregulated militia of Virginia. And that is by, in the code. And can be called up by the governor at any time. So I think, there are a number of issues that deserve some consideration and discussion in this committee.
Senator McDougall.
Claire, I'd ask this of you instead of Senator Lucas just because of your legal background. This says assemblies of one or more person with the intent of intimidating, drill, parade, or march. Would that not include the National Guard that's called up to keep the peace, or anybody at our military bases, of which we have a number in my district and around the Commonwealth? Because it doesn't say that the person has to be in close proximity at all. So doesn't that, it hits a lot more than the situation that's articulated, does it not?
Mr. Chairman, Senator McDougall, I think that you've illustrated that there are some vagueness issues with this, and it's unclear exactly who it applies to or how it would be enforced.
Well, I appreciate your stepping up. Steve, you have any thoughts about the constitutionality?
I can't say that it's unconstitutional on its face. It may be unconstitutional as applied. It is almost identical to our current statute that criminalizes burning a cross with the intent of intimidating any person or group.
Is what?
Mr. Chairman.
Senator McDougall.
Steve, if the example of all of our military bases or the National Guard, if they are organized and displaying any sort of force to keep the peace, could they not be in violation of this statute? Because certainly their intent is to intimidate. Certainly the military is trying to intimidate some of our.
Mr. Chairman, I don't think so. I think that when they act in that fashion, they're acting to enforce the law, to preserve the peace. I don't think anybody would say that they were acting with an intent to intimidate.
Mr. Chairman.
Senator McDougall.
So you're telling me our military is not trying to intimidate our enemies not to attack us?
Well, Mr. Chairman, that's not a legal question that I can answer.
Okay.
Mr. Chairman.
Senator Peake.
And I think this is to Mr. Benjamin. Isn't that cross-burning statute currently in front of the Supreme Court?
It's the new statute that is before the Supreme Court.
No, it was before the Supreme Court, and it was unconstitutional because it contained a presumption of an intent to intimidate. That was unconstitutional. This is the current constitutional version.
Mr. Chairman, I have a proposed amendment that would say on line 23, assembles with one or more person with the malicious intent to and does intimidate.
Got that?
And then it goes on to say any person or group by drilling, et cetera, with explosives or incendiary devices, et cetera.
Got all that, Kristen?
Yes, Mr. Chairman.
Is there a second to that motion?
Second.
Really? You like that amendment?
I like that amendment.
Okay. You want to read it?
Mr. Chairman, so on lines 23, it would read, assembles with one or more persons with the malicious intent of intimidating and does intimidate, and then any person or group of.
So that might not get to Antifa and the groups in Charlottesville if, you know, they just engage in combat and are not intimidated. Is that right? Steve?
That's right.
Okay. All right, the amendment's before us. All in favor signify by saying aye.
Aye.
All opposed? No. Well, let's open the roll on the amendment. Senator Lucas, you want to cast your vote on the amendment?
I thought I just
Sorry, there
did.
you go.
There you go.
Oh, I pushed it, it just didn't register.
7 noes, 8.
All right, the amendment fails. Bill's before us. Anybody wish to speak in favor of this bill? Step right up.
Thank you.
Good morning, Victoria Pearson, Deputy Attorney General, Criminal Justice and Public Safety. Happy to speak on behalf of this particular bill, which we all know addresses some of the big concerns that came out of the Charlottesville incident. This language would be added into the already prohibition in the state code that pertains to paramilitary activity. As was stated by Senator Lucas, it already prohibits the teaching as well as demonstrations of paramilitary activity, training and practicing, instruction with firearms. So this is not creating a new group of individuals that would be banned or a new group of people who could not do things. This just adds to it the conduct of intimidating individuals through marching and drilling while doing so with a firearm. As you may or may not be aware, there was a group of about 32 individuals carrying large rifles dressed in a confusing manner that looked like our Virginia Guard, which were not there for purposes of maintaining the peace. They were not there for purposes of enforcing the laws of the land. They were there for a separate purpose that was their own pecuniary purpose, which was very different and distinct, but could confuse other individuals, which is part of why this particular statute already exists. So this is a language to try to give law enforcement an additional tool to address paramilitary behavior and to reach some of the things that we found very disconcerting about August 12th.
Is this an Attorney General's bill? I thought that you all had a broader bill, maybe through Delegate Price.
We look forward to bringing that bill forward, yes, sir.
All right, is that it pending in the Senate or?
That's House bill.
Okay,
We hope it'll be pending.
okay. All right, thank you very much. Appreciate it.
Mr. Chairman, I just have a question, and I don't want to beat a dead
Senator
horse.
Reeves.
As a cadet, I used to drill on our drill team with rifles and bayonets, and it was our intent to beat the other teams, to intimidate them and the whole bit, because we'd like to win the competition. Wouldn't this bill at this point make it illegal for drill teams with military precision weapons and all that stuff to do that? I mean, this would catch them up.
Mr. Chairman, Senator Reeves, returning to Senator McDougal's point, I think that the amendment then would be to say maliciously assembles and so on. That would call out those who are lawfully acting in the capacity that you describe. Just add the word maliciously in front of assemble.
How do you prove a malicious, what is a malicious assembly? What about, well,
Bear in mind, Mr. Chairman, that
isn't it in the eye of the beholder? And isn't that what we're trying to, I mean, you know, look, I mean, we certainly want to protect people against malicious behavior, but we also have constitutional protections for unpopular behavior. And it doesn't mean that we agree with it, that we think it's not despicable, but it's a tough line to.
Mr. Chairman, you're absolutely correct, but the distinction is that speech with the intent to intimidate is not protected by the First Amendment. And we criminalize conduct and speech throughout the code if it's done with the intent to intimidate.
Mr. Chairman,
Right.
Mr. Chairman, further I'd point out, if Texas A&M's drill team or militia is acting in some official capacity, I mean, there's no intent to intimidate there. That's a performance. There's a huge difference. Or that they're carrying out an official act on the part of the state.
See if anybody
That's
wants to
very
speak
different.
in opposition to this bill. Seeing nobody, the bill is before us.
Okay,
Move the report.
can we slow down a second and actually talk about it? Because, let me ask a question. Is it only the person that carries the firearm that's liable for the Class 4 felony, or is it anybody that's basically part of this crowd?
The bill speaks to
Or
firearms.
marching with any
Yeah.
firearm.
Yeah, the bill speaks to firearm.
No, it speaks to assembles with one or more person with the intent to intimidate by
Right.
drilling or parading or marching with any firearm.
Right.
So it would seemingly apply to drilling or parading irrespective of whether
No, it wouldn't. No,
it's in connection with the firearm.
no, it wouldn't.
Okay. I mean, the word "or" to me it means it would be in addition to. I don't know what the drilling or parading part is. Marching with firearm, I totally understand, and that I have no problem with, but drilling or parading, I mean, look, you can parade as a First Amendment right. I don't see how you can stop somebody from parading.
Mr. Chairman, on line 24, if you add a comma after the word marching, it clarifies that the conduct is criminal if it's done with a firearm.
I'll move that amendment.
The comma?
And that's without regard to whether it's
Do we already have a comma, Bill?
visible or not.
Mr.
So
Chairman, the
it
bill is
doesn't-
silent on that. We could clarify.
And how about okay,
Mr. Chairman,
fireworks?
Mr. Chairman, I don't think it matters if it's visible or not. If the intent to intimidate while you're carrying a weapon or an incendiary device or an explosive is the offense.
But it's, so just to Senator Peterson's point, let's be clear about what we're criminalizing. It's behavior intended to intimidate. If you have a firearm, irrespective of whether anybody knows you've got it, that is being criminalized.
Understood, Mr. Chair. I think the
Mr. Chairman.
comma makes the bill, I think that provides the clarification for the patron's intent.
Mr. Chairman,
Senator Stewart.
it would further complicate it. That would also be true if they had a firework in their pocket or a box of matches, potentially.
Later.
Well, Mr. Chairman, whether they knew it or not, the question is, you got to prove intent to intimidate. And you could argue, well, they didn't know there was a firearm, so there's no
Well,
intimidation
doesn't
there.
that
but
depend
then-
on what they yell? I mean, you can yell something that's meant to intimidate.
That's why I like the word malicious that I put in there that you voted down.
All right.
Mr. Chairman.
Senator Stewart.
If I could ask Mr. Benjamin, why doesn't our current brandishing statute cover what they're trying to get at?
Because,
Short
Mr.
of an
Chairman,
assembly, but.
because, Mr. Chairman, brandishing requires an actual brandishing of the firearm. This bill would reach those who are visibly armed, but not brandishing.
Well, brandishing is an intent to intimidate, using it with an intent to intimidate, isn't it?
I'll check to make sure.
And so, Mr. Chairman, the only other element is that you're adding an assembly to it versus a brandishing.
Yeah. All right.
Yes, Mr. Chairman, brandishing is where you brandish a firearm in a manner so as to reasonably induce fear in the mind of another.
So in this instance, assembling with firearms with the intent to intimidate another is a crime under Virginia law
That's what it says.
right now.
The current law provides that it's a crime for any person to point, hold, or brandish any firearm in such a manner as to reasonably induce fear in the mind of another.
Okay?
And I think the patron's point is that there is a separate crime or a greater crime when two or more people assemble and do so with the intent to intimidate. The brandishing applies to one person. The patron is pointing out that an assembly, especially a large assembly, is a graver offense, if I understand the patron.
That's correct.
Mr. Chairman,
Sarah Stewart.
I can't recall this exactly, but Mr. Benjamin, isn't there a statute that talks about one or more persons gathering for purposes, they call it a riot statute generically, but it's when one or more persons gather together and commit a crime. And so that's why I think this is all covered already.
Bob, yeah.
Mr. Chairman, riot is the combination, actually, riot is the unlawful use by three or more people of force or violence which jeopardizes the public safety, peace, or order.
But, Mr. Chairman, there's another statute which actually makes it a heightened offense if there's one or more persons committing a crime. And I can't call that statute right now.
All right.
I think that's unlawful assembly.
All right, the bill's before us.
Move report.
All right, it's been moved. Is there a second?
Second.
And seconded, the bill be reported. And it needs to go to finance, reported and re-referred to the Committee on Finance. Clerk will open the roll.
Ayes 7, noes 8.
All right. Bill fails to report.